Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In the jurisprudence classes, in the natural school of law, I have told you that the principles of natural justice, they are there right from the beginning, since the inception of the human society. So to maintain the balance, the principles of natural justice should be followed. So the second principle of knowledge, as a jurisprudence, second principle of natural justice, I have been telling you is Audi, Alterm, Partem. That means hear the other side. This should be done. Whether you agree with him or not is a different thing. But first of all, give him a chance to represent his matter. Then you take this. This is one of the most important fundamental principles of natural justice. If it is not there, then whatever order, whatever judgment you will give becomes void. So, please remember in this connection, Justice M. Nagaprasanna, in the case of K.B.Naik, he is advocate, previously Karnataka State Bar Council President also, Chairman also. K.B.Naik versus Bar Council of India and others. In WP number 20983 by 2022 on 17/11/22, this Justice M. Nagaprasanna held that even God has given a chance to Adam and Eve for eating the poisonous fruit. He has given a chance for hearing about as to why they have eaten the so-called poisonous fruit. So God himself have given the opportunity of hearing to Adam and Eve before passing off the sentence. Here no such chance was given to the defendant or Mr. K.B.Naik. Right. So actually an advocate by name Basavaraj Murgesh is an advocate. He filed a complaint against the so-called K.B.Naik. So stating that he has conducted or he has misbehaved himself. He has not followed the professional rules or professional ethics. So particularly rule number 21, which says the advocate should not engage in trading or buying or selling the client's property. Actually, the clients, they are involved in a case of 307 and so many sections are there. So crime number 39 by 2007. So therefore, since they were involved in the case, they have approached K.B.Naik and he has taken their signatures. He has misused their signatures. He has converted them into the gift deed by which he has sold away their properties. So for the restoration or for the dismissal of the so-called transaction, they have to file once again OS number 14 by 2008. So declaration of sale as null and void. So since he has showed the so-called misbehavior, as per Advocates Act, they filed a complaint to the Bar Council of the state. Ultimately, the matter went to the Bar Council of India. Bar Council of India, through video conferencing, they wanted to contact this gentleman. He did not come onto the video conference. Ultimately, they have passed suspension orders against him till the disposal of the so-called complaint. Yes, you know. According to Section 35 of the Advocates Act, the Bar Council of India, definitely they can appoint a disciplinary committee containing a senior judge and two other judges, senior advocate and two other advocates who will, please remember, who will conduct the inquiry according to the procedure. That is, they have observed the so-called principles of natural justice. Here, please remember, the High Court of Karnataka, Justice M. Nagaprasanna, he stated that 48A of the Advocates Act says that no order which prejudicially affects any person shall be ordered, no order, please remember, without giving reasonable opportunity. So the suspension order should not have been given without affording him a reasonable opportunity. No doubt, he might have misused the signature of one of his clients. He might have, without permission, he might have sold the property. But he should have the opportunity of being heard, for which the BCI, it has no answer. So therefore, the principles of natural justice were not followed. Why they were involved? It is to show that there was a fair play. So even God asked Adam and Eve. So please remember that too, this order of suspension, it affected his livelihood, not only professionally. So if the lawyer doesn't have clients, what he has to do? It is affecting his career or so-called livelihood also. Therefore, ultimately, the Honorable High Court of Karnataka was pleased to set aside the order of suspension. At the same time, please remember, they have set aside the order of suspension. At the same time, the matter is remitted back to the Bar Council of India. Bar Council of India will take up the matter, will give a chance to the K.B.Naik for hearing, then they can decide the matter. This is what is called remission. So they can pass appropriate orders. Very good judgment. So this shows the wisdom of the judge. Wisdom of the judge. So no doubt, the act done by the advocate is heinous. It is against professional ethics, but still, principles of natural justice, they have to be followed. This is more important. So please study the case law and enrich your legal knowledge. With this, I am stopping. Thank you very much.